totally limited on the electoral commission and others.
Yes, Mr. Straker.
And it please the court, I, with my learned friend Mr. Tunbridge, appear for Vote Leave Limited. My learned friends Messrs. Coppell and Meta appear for the Electoral Commission. The interested parties don't appear and are not represented, although you'll have seen that Mr. Grimes has made a witness statement in this matter. And I proceed upon the footing that a chance has occurred to have at least some reading of the matter before we've come into court, and so I'm going to go straight, if I may, to the essence of this case.
That would be very helpful, Mr. Straker. You're quite right to say that we have had quite a good chance to read fully into
I'm
it.
much obliged.
And as you know, my lord and my lady have background, though
Yes.
it's not relevant to this particular issue. So I
There is, in fact,
can assume we know it
relevance
pretty well.
when we come to deal with common plan expenses, where that will be particularly useful
Yes.
experience. The essence of this matter is as follows. There is and has been an unlawful arrogation of power by the Electoral Commission, having and clearly intended to have the effect of a sanction on those named in a report, published and publicised by the Electoral Commission, for which report there is no identifiable power to make, publish or publicise, and which in any event is out with the clear code that Parliament created for sanctions in respect of the referendum for June 2016. Such arrogation of power has unpredictable but clearly prejudicial effects, and is entirely inconsistent with the principle in electoral law on which the legislation as to referendums was based, that officials do nothing beyond that which is strictly provided for in the relevant rules or legislation. And there are two reasons for that particular principle which has come to be enunciated in electoral law, at least two reasons. First, that there is a code which has been given so that, for example, every last contingency is dealt with in, for example, the parliamentary election rules which are scheduled to the Representation of the People Act. And second reason is because of the unpredictability of taking steps which are not provided for, at the very lowest, there is a risk that taking a step which might in another context appear altogether sensible, it's only 1 minute past 12, the time limit is 12 o'clock, therefore why not accept the nomination? The effect of stepping outside the rules, being unpredictable, can lead to an apprehension or even an appearance of partiality. The court should note
So just pausing there, you've been saying what the essence of the case is.
Yes.
Are you still on the essence, or are you about to develop it?
No, I'm about to develop it.
Well, in that case, could I just check? I've written all of that
Yes.
down. The essence of the essence, it seems to me, if I got this right, is that there was no power under the statute for the Commission to issue the report that it did. That is the legal proposition which underlies the points you've just been making. Have I got that right?
That is correct. And adding to that, if I may, because it is an in any event point, the legislation provided a complete code for the way in which sanctions were to be dealt with, which is not to be departed from.
Well, I see that, but I just want to get this analytically correct. That is a supporting argument for the fundamental proposition that there was no power to do this. You say,
Yes.
but in order, one of the arguments that shows there was no power to do this is that there was a self-contained code which didn't include
I
this.
would readily accept that proposition, that it supports, but it plainly is a very important support to the argument, because it has a freestanding character of its own, because one can see everything happening within the code, and therefore why do anything out with the code?
Right, thank
And
you.
I'd ask the court to note, please, moving on from that essence, that the report with which these proceedings are concerned is of a character never previously published by the Commission. The evidence is to that effect. I'm just going to give the court references here, if I may, rather than invite the court to turn it up. Moynihan 3, paragraph 17, 31st of July of this year, supplementary bundle 383, which has not been denied or questioned in the subsequent Commission's evidence, being Lardner, page 396, supplementary bundle, and following, dated the 30th of August.
Could you just help me? Have there been other civil penalties prior to this one, which would have been an occasion for such a...
There have been such civil penalties. I'm afraid I'm not in a position to tell your lordship how many or precisely when and against whom, but there have been previous civil penalties. The Commission has now been in existence for getting on for 20 years.
Yes, but the civil penalty regime is newer.
It's more recent than that, yes.
Okay, thank you.
But we are concerned with an activity which can't be taken to be supported by previous practice. And I'd also at the outset like the court to notice that the evidence for the Commission is that the report was published under a duty said to be imposed by the Freedom of Information Act 2000. That is given by Mr. Lardner, page 398 in the supplementary bundle at paragraph 8, which is entirely different from anything said before by the Commission, which is in the Freedom of Information Act being unmentioned in the report, which is at core bundle pages 91 and following. The only duty mentioned in that report is section 145 of the Political Parties Elections and Referendums Act of 2000. See paragraph 1.2 of the report.
That's not the way, of course, just so that there's no misunderstanding, that Mr. Copple primarily puts it in his skeleton argument.
That's right. There appears to have been a slight shift in emphasis from the detailed grounds of defence to the skeleton argument, but I've understood that there are three bases put forward in the skeleton: an ability to publish information, so to speak, come what may. Secondly, a consequence of the legislation bearing upon the Electoral Commission, and thirdly, the freedom of information point. But in any event, the freedom of information point is new. Can I just mention, on a point of documents, that the report which I've mentioned at Core Bundle, page 91 and following, is a copy of the report as it was given to those who received it at the time, to include all the news outlets, BBC and so forth. There are two further copies of the report in the bundle, the dates for which are quite difficult actually to ascertain, but don't appear to be the date of the 17th of July, and there have been over time various matters which have been added to the front, at least, of the report. And sometimes it's been quite difficult because of the way the internet operates and because of the way the documents are put up, to identify precisely what is the report at any given stage.
But so we can be clear about this, you are complaining about the report as originally published, which is the version we have in the core.
That's right,
Yeah,
and that's
well,
the one that the court should plainly focus upon, and that's the one which, in all its essentials, remains to this day, notwithstanding the decision, for example, of His Honour Judge Dyte, upon the website of the Electoral Commission, and that's the one which will be filed away, no doubt, in the news desks of the BBC, the Times and so forth. Consequently, there are two related themes at the outset of my submissions to have in mind. Does the power exist, and is it out with the statutory regime or code? And in order to do this exercise as efficiently as I may, because I'm going to try, my lords, always, if I can, to do things in a way which takes the least amount of time, taking full account of your lordship having told me that the courts had an opportunity to read the material. If I go too fast in that way, I hope and trust that the court will tell me and I can adapt accordingly. But yesterday, in order to speed matters as far as this aspect is concerned, we provided to the court three new documents by way of authorities, including an extract from the Encyclopedia of Local Government, a 33-page document, and I think when it was supplied to the court, it was noted that particular paragraphs of significance included paragraph 1.1-12, which is to be found at the foot of page 4/33.
Yes, thank you. We certainly got this. Speaking for myself, I didn't have an opportunity to read it. So if there's
Thank you.
passages you wanted to refer us to,
Yes. Well, what I wanted to do, because
do so.
we're concerned with a body, the Electoral Commission, which has got corporate status. and consequently a body which is subject to the doctrine of ultra vires, and that doctrine as applied to a statutory corporation is recorded, foot of page 433.
Sorry, now 433. Oh yes, sorry. Yep, I have it. Thank you.
As I say, I'm doing this in this way to avoid turning up the cases and taking time in that way, because this is all straightforward principles which have been expressed in this way in the Encyclopedia of Local Government Law for years, repeated in the same language in Cross on local government. And one sees there the doctrines applied to statutory corporations stated in Lord Watson's speech. Whenever a corporation is created by an Act of Parliament, that happened here, with reference to the purposes of the Act, that happened here, and solely with a view to carrying these purposes into execution, that's the case here, I am of opinion not only that the objects which the corporation may legitimately pursue must be ascertained from the Act itself, but the powers the corporation may lawfully use in furtherance of these objects must either be expressly conferred or derived by reasonable implication from its provisions. Unlike a natural person who can in general do whatever he pleases, so long as what he does isn't forbidden by the law, a statutory corporation can only do only, it says, those things which is authorised to do by statute directly or by implication, if otherwise ultra vires. Now, if we pause there, your lordships and my lady were also provided yesterday with a copy of, which was otherwise absent from the bundle, with a long title to the Political Parties Elections and Referendums Act, so that the court can see what it was that Parliament was doing and what it was Parliament was providing for when it established the Electoral Commission. And this is on it's a single sheet of paper, but it's probably attached to the list of sections of the Act which follow, which is a 26-page document. And so the court will see from that long title that it was an act to establish an electoral commission, to make provision about registration and finances of political parties, provision about donations and expenditure, contrasting those two matters for political purposes, make provision about election and referendum campaigns and the conduct of referendums, to make provision about election petitions and other legal proceedings in connection with elections, and then to do certain other matters and for connected purposes. So it was legislation intended to cover all those matters and to make the provision that Parliament thought necessary for them. And if you just cast your eye, if you don't mind, over the arrangement of the Act, you will see that it is perfectly plain that this was a comprehensive exercise being undertaken by Parliament. Because on that opening list, you see the establishment of the Commission, which is done by creating a body corporate, and then the Commission's general functions, section 5 and following. There have been amendments, and so those are included within. Then, as enacted, turning the page, there were electoral boundary functions. And then there was a function relating to, or functions relating to core, which was intended, when introduced, to be a central mechanism of registration of electors, but that's now gone. And then just turning the pages, one sees all matters which are contained within the legislation, and one gets to the question of enforcement at section 145, with civil sanctions being recorded under the heading of 147. And Schedule 19C is itemised here as well, which is the provision dealing with the sanctions with which we're concerned. And can the court please note that Schedule 19C called for further regulations to be made, and that led to the third of the three documents that was provided yesterday, the political parties.
Which is the paragraph that requires
Oh, it's paragraph 1 and several others of Schedule 19C.
Oh, I see, okay.
Yeah. And if your Lordship has the third document that was provided yesterday, your Lordship will see at the top of the bundle, which has 1/23 at the foot, the Civil Sanctions Order of 2010, your Lordship will see that the order was made in exercise of powers conferred by, and then there's a list of paragraphs at the top. So it's not just the first paragraph, but the first paragraph did entitle it. And so this was done as required to be done, and what I would ask the court just to note at this stage, please, is that at Article 7, withdrawal or variation of a notice is provided for. The Commission may by notice in writing at any time withdraw any final notice. They can do other things to it as well. And then 8 is the provision which provides for an appeal, which contains 2, what the court, in England the county court, can do on appeal. And if the court just glances at that and has in mind that when you come to look at His Honour Judge Dyke's judgment, there are misprints which come in his judgment as to the text of 8.2. But withdrawal or variation is provided for. Now, can I then, with all that in mind, draw attention to the actual terms of the legislation, which you have in the bundle of authorities A, which deals exclusively, I think, with legislation. So that the court will see that at page 1 we have what I've said there is a body corporate section 1, subject to there plainly then the rule which we've seen in the local government encyclopedia. If you go on please to page 3 in this bundle, section 5, you will notice that reports are expressly provided for. They're expressly provided for here and elsewhere on given subject matters, so that section 5 requires, shall, after each referendum to which part 7 applies, prepare and publish in such manner as the Commission may determine a report on the administration of the election or referendum. Now, the report with which we're concerned is not such a report. And you will also notice that similar obligations to make reports occur to A, at the foot of page 3, parliamentary by-elections. After ordinary election of councillors for local government areas in Scotland, to B on the following page. After after a poll held in Wales, if requested by the National Assembly for Wales, a report on the administration of the poll, and after the end of a recall petition period, a report on the actions taken or not taken.
Those are all mandatory.
Yes, so subject to the one concerning Wales, where it's dependent upon a request by the National Assembly for Wales.
But still mandatory.
It's still mandatory if a
Mandatory
request
if
has been
requested,
made,
yes, thank you.
And so Parliament clearly recognised that there were going to be occasions when reports stood to be made. Not merely then, but also if you go to the next section, section 6, page 7. Reviews of electoral and political matters. Keep under review and from time to time submit reports to the Secretary of State on the following matters. Namely, I don't read on, but this once again is not such a report, though Parliament provided for such reports. Page 11 can be noted in this consideration of the Act. This was a section which at one stage was relied upon by the Commission as giving them power to do that which they did in this Act, in this matter, but it's no longer relied upon. But you see what it provides. The Commission can, at the request of relevant bodies, give advice and assistance. And so no doubt that could take the form of a document being given to, for example, returning officers at elections. Section 13, also once upon a time relied upon by the Commission here, but no longer, provides for education about electoral and democratic processes. And then if you could go please to page 19, just a notice that we get here to part 7 of the Act, which deals with referendums, and by section 128 there has to be a chief counting officer who is the chairman of the Commission. So that what is happening is that on a larger scale, of course, because this is a national exercise, the Electoral Commission, through the chairman, are stepping into the shoes which would otherwise be filled for a parliamentary election or a council election by a returning officer. At page 29, the court will see section 147, which was substituted by later legislation, the Political Parties and Elections Act of 2009. But you'll see there it indicates that Schedule 19C is the way in which provision for civil sanctions is made. And at 136...
Just before you
I'm
go,
so sorry, my lord.
forgive me, do we need to look at all at section 146 and schedule 19?
Section 146 deals with investigatory powers of the Commission, and Schedule 19B, as it says on page 27, makes provision about those investigatory powers.
Yes.
And one report, one notice which was made against Vote Leave Limited referred to supposed misconduct under Schedule 19B by Vote Leave Limited, but save, at the moment at least, for understanding that, I'm not sure that one needs any further and better understanding of Schedule 19B.
Well, you may be right, but in my brief look at the legislation in preparing for this hearing, I noticed that there is specific provision about making a report about Schedule 19B matters. That we see that at page 57.
There also is for Schedule 19C as well, my lord.
But that may be right.
Yes.
The same point may hold good. Can we just look at the one at page 57?
Yes.
Do you see paragraph 15?
Yes, because what that does is take you back to Schedule 1,
Yes,
which I hope is in the
it is.
bundle.
Paragraph 20.
Yes, and that's
That's page 46.
absolutely, my lord, and that's the provision which requires a report each year to go to the Houses of Parliament.
Yes.
And so, once again, one's got an exercise which is entirely consistent with the thesis which I'm putting to the court, that Parliament through the legislation has provided for reports when it has wanted reports, empowered the Commission to make those reports, and said that one such report has to be made if there's a Schedule 19B matter,
Yes.
and also it says exactly the same, but this time I think it's paragraph 25 in Schedule 19C,
Yes.
where it provides for reports, so that I've got it wrong. It's not that. It's 27. I'm so sorry, I got that number wrong.
I missed that, so I'm grateful to you for pointing that out to us.
It's paragraph 27 on page
I see
72.
that. Same 72, yeah, I see that. Now, do you derive some assistance for your submissions by the presence of these specific provisions?
Absolutely. Absolutely right, my lord, because, if I may say so, it doesn't take much to work through Schedule 19C, and one could do the same for Schedule 19B, in fact, as well, to work through Schedule 19C to see precisely what is happening, and then to see precisely what is required by the legislation to happen. You, the Commission, have to, in the reports you make under paragraph 21, the annual parliamentary reports, have to put in there information about the use made by the Commission of their powers under the schedule during the year in question.
Mr. Straker, I do see why you put it like that, of course, but it might be said that these are provisions where Parliament has required something to be done by the Commission. Does it necessarily follow from that Parliament has not empowered the Commission in other circumstances to make a report?
Well, it doesn't follow from the fact that these reports have been expressly empowered. It doesn't follow that there can be no other empowerment to make some other kind of report.
Yes.
But then the question comes, where is that empowerment?
Yes.
And the answer I come back with, I'm very sorry, I can't help your lordship on that, because there is no such.
Yes.
And I add to that answer I've just given to my lord to say it's not surprising I come back with that answer, because reports are fully dealt with in the legislation, which then I can lead into my point about the code and matters of that sort. Yes, and I wanted to draw attention here, if I may, just to one aspect, as to how, having drawn attention to Section 147 and the Schedule 19C, which we'll have to look at further, but if you look at, as you will already have done, but I just pick this out if I may. It's perfectly plain that the Commission viewed this report as part of enforcement action and sanctions, because at page 136 of the core bundle, at paragraph 19, attention is drawn to the fact when considering this report to the Electoral Commission's scheme.
So sorry, you're going too fast.
I beg your pardon, my lord.
We are in what Mr. Cobble still as an argument.
No, we're in the detailed grounds of defence.
I'm so sorry, I must have misheard you.
Resistance.
136.
Page 136, yes.
Of which, what bundle?
Core bundle. It's tab 13.
Oh, I see. I'm so sorry. It's the detailed grounds of resistance. Yes, I'm with you now. Yeah.
This is the one which I contrasted earlier on when having that discussion with your lordship about.
Now, just sorry. Show me again.
It's
which
the top
paragraph?
of page 136.
Yeah.
Where there's a discussion about, in the context of this report, and indicating that the EC's publication scheme and how this report is then regarded will publish decision-making processes and records of decisions in relation to enforcement action and sanctions.
It's in relation to, that's all they're saying, that it is a report in relation to sanctions. They're not accepting that it is itself a sanction.
Well, in other places, it has been seen as having a sanctioning effect. What it comes ultimately to be described as is perhaps a matter of semantics, but undoubtedly a report by itself can be a sanction on the party reported upon.
Why?
Well, it depends what it says. If I has a report about me which says everything is truly wonderful about me, I'm not going to view that as a sanction. But if there's a report because of some misconduct by me, which records this item of misconduct and publishes that item of misconduct, that undoubtedly would be a sanction on me, even though the sanctioning body went on to say, because of Mr. Straker's known deficiencies in other fields, we're not going to impose any sanction.
Is that correct? I've always understood a sanction to be some sort of exercise of a power to effectively to punish. Now, to say something bad about some person will certainly have ill effects on them, but it's not the same as a sanction. The civil penalty is the sanction in these cases. If you produce a report at the same time or roughly the same time, that's not the sanction.
Well, it is capable, I would respectfully say, of being seen as a sanction if one puts it in a different context and supposes the circumstance where one has a professional committee reaching a judgment over someone's conduct and arrives at the view that the matter is to be dealt with by a reprimand by the president of whatever professional body one is concerned with, then one would, I would respectfully say that is clearly to be seen as a sanction.
Well, I agree entirely, but that's because there is an official reprimand.
Well,
I don't. We haven't yet got to the report, but we obviously read it. I don't see any reprimand in it. It records the sanctions which have been imposed separately by the notices of civil penalty. But it's not itself a sanction, is it?
well, it's not itself a sanction in the sense that it doesn't impose a penalty upon, but it is a sanction, I would respectfully say, in the sense that it has the consequence of the circumstance that we've just discussed, of the reprimand being provided to the professional person by the chairman of the relevant committee, or a report done in connection with somebody so as to say, I draw attention to these following matters. for example, the ombudsman have no particular power, as far as local authorities are concerned, to say you must do X or Y in consequence, but they have the power to require a local authority to publish a report about itself, which, if the ombudsman has found maladministration, will operate as, I would respectfully suggest, equivalent to, in that circumstance, a reprimand or a sanction in that way. But in any event, one still has to be able to find the position and to find the power for it. Could I just go back, please, to the schedules in the Act to draw attention first to Schedule 1 so that the court can notice paragraph 2 of Schedule 1. And paragraph 2 is written in the same or similar language to a corresponding provision in the Local Government Act 1972, which enables that which is incidental to be undertaken, so that the Commission can do anything, say borrow money, which is calculated to facilitate or is incidental or conducive to the carrying out of any of their functions. And we can just notice, perhaps in passing, that you can't have something which is incidental to the incidental. It's got to be incidental to a function, so one's got always to be able to identify a function. Schedule 19C begins at page 59 of this bundle of authorities. And part 1 deals with so-called fixed monetary penalties and provides a regime for those. And part 2 deals with discretionary requirements. And it's within this part that Vote Leave Limited found itself accused of being by the Electoral Commission. And you'll see that the Commission can impose one or more discretionary requirements if satisfied beyond reasonable doubt of one or other of certain matters there set out. Paragraph 6 provides a scheme for representation and appeals, etc. And so that one has to go through a process of a preliminary notice and then a final notice.
Sorry, I'm being slow. I probably skipped something. Part 1 deals with fixed monetary penalties, and paragraph 1 gives the power to impose the penalty by a notice. Then there's representations and appeals in relation to that at para 2.
Yes.
And then we have the separate provision as regards discretionary requirements in part 2, the separate scheme.
That's right.
With a parallel structure.
That's absolutely right. And we are within that because it was discretionary requirements that were imposed upon Vote Leave Limited rather than fixed monetary penalties.
Yes, I see. I hadn't picked that up. Thank you.
Yeah, and so paragraph 5.
Just for my own education, what's the definition of a fixed monetary penalty?
I'll have to, the interpretation schedule records that having the meaning given in paragraph 1.5, which is a requirement to pay, page 60, the commission a penalty of a prescribed amount.
Yes, I saw. I'm sure you're right. I had just reading through this and not that point focusing on this part of the detail, I had assumed that because the vote leave was ordered to pay £20,000 and £20,000 and £1,000, those were each fixed monetary penalties. They're not.
They're not. They were discretionary penalties imposed in consequence of Part 2. And the discretionary requirement will also be defined
Yes,
in
I see.
5.5.
5A, yes, I've got that now.
Yeah.
So fixed monetary penalty must be, there is somewhere, we haven't been to it, a list of if you do this, it'll be £1,000.
Absolutely.
Okay, I'm
Absolutely.
there. Thank you. That's very helpful.
And so 5 is the ability to impose on a person, if satisfied beyond reasonable doubt that the person, and a person here appears to mean singular as opposed to a collection. And then we have paragraph 6, a procedure which has to be gone through where they propose to impose a discretionary requirement. They have to serve a notice of what is proposed, allowing for a period of representations. And then 6.5, where they decide to impose a discretionary requirement, they shall serve on the person a notice specifying what the requirement is. And Article 7, paragraph 7 I should say, paragraph 7 tells us what has to be included first in the notice for the preliminary notice, and second at 7.3, the notice under 6.5, which is the final notice, which actually says please pay. And if you look at 7.3, you will notice that it's very particular as to what has to be set out. The grounds for imposing the discretionary requirement. When it's a variable monetary penalty, how payment may be made, period, early payment discount or late payment penalties. Rights of appeal, please notice that in particular, and the consequences of non-compliance. And then if one looks on, we can see that the similar provisions are made for other circumstances, but Part 5 enables the Secretary of State to make supplementary order supplementing that made by this schedule, make provision that is consequential on or incidental to that made by this schedule. So the Secretary of State, so to speak, has had reserved to him or her the ability to make provision. Parliament's provided for that, hasn't provided anybody else to make a further provision. And then on the, in Part 6, if you notice, the Commission have to prepare and publish guidance as to the sanctions that may be imposed on a person who, the action the Commission may take in relation to such a person by virtue of this schedule or otherwise, the circumstances in which the Commission are likely to take any such action. The guidance must include guidance about. So this is an obligation on the Commission to publish guidance about what it can do under the legislation.
Well, more specifically about what sanctions it can be.
Yes, yes,
imposed.
exactly so, exactly so. And those sanctions are quite plainly the sanctions which are set out in the legislation and not otherwise. So if we pause again at this stage, we can identify and have identified clear functions as to civil sanctions. We can identify a power to operate the civil sanctions regime. We can also identify the fact there's a clear code, a clear set of provisions dealing with those sanctions. And if we go back for a moment to once again to try and do this as efficiently as possible to that local government encyclopedia clip that I mentioned at the outset. If you go to page 11 of 33, you'll see a reference to the case of Hazel, which is also in the bundle of authorities, and if I just give the reference in the bundle of authorities, it's flag 6, page 119. But notice this involved speculative financial transactions, interest rate swaps and so forth, and there was a lot of litigation at that time about such matters. And if you look at the foot of the page, the divisional court allowed the application, holding couldn't rely on royal charter as giving capacity of a natural person to enter into contracts. No express statutory power that authorised the transactions, didn't fall within the 13th schedule to the Local Government Act. Not authorised by the incidental power. They didn't assist the council to borrow, although they might have been able to assist the council to alleviate the consequences of borrowing. And then if you look on, please, to 13/33 at the foot of the page, the authors, having discussed what happened in the Court of Appeal, then tell us the House of Lords restored the division of the Divisional Court, functions all powers and duties, swap transactions not incidental to the function of borrowing, speculation in future interest rates, trades with the object of making a profit. Schedule 13, a comprehensive code which defined and limited the powers of a local authority with regard to borrowing, inconsistent with any incidental power to enter swap transactions. I don't need to, and therefore don't, read on further. Now, Vote Leave Limited were the recipient of 2 notices which your lordships and my lady will have seen in the supplementary bundle at pages 113 and 151 respectively. Tabs 14 and 15. So 113 is the one which has been mentioned, so to speak, figuratively, the 2 monetary penalties of 20,000 and one of 1,000, making £41,000. And the other one, 151, is another £20,000. And if we take the other one as just indicating what they were saying, you will see that at 151 it just records what it is. At 152 it reflects Schedule 19C by telling us how you can pay and what happens if there's late payment. At 153 it records the grounds of appeal, and please notice those grounds of appeal. This is not merely an appeal on the basis that this is wrong in law. This is an open-ended appeal on the merits, error of fact, wrong in law, amount unreasonable, or the decision is unreasonable for any other reason. That reflects the legislation, and at page 155, grounds are set out for doing what they have done. Now if we look, please, bearing in mind that those notices could only be imposed on one person at a time, if we look at page 91 in the core bundle,
Will we be coming back to these notices?
I suspect so, yes.
But not immediately.
Not
No,
immediately, no.
Way, thank you.
Tab 10 of the core bundle. Page 91. This is the report. So one sees on its facing page, on its face page, that it's in respect of 4 named bodies. And we notice that the notice has to be in respect of 1. We can see page 94. Paragraphs 1.1 and 1.2. That this is to do with, or something to do with, section 145. And then paragraph page 95 and following, we can see what is set out by way of summary of findings, summary of offences and penalties, decision to investigate, scope of investigation, the investigation, determination of offences, the investigation findings, joint spending.
Sorry.
I'm just turning the pages really just to show the court what this report contains, because it goes on and one gets to 1, 2, 3 final determination of offence on offences, and then Annex A 125 legal and regulatory framework. And so can the court please notice that no grounds are identified as such. Compare what has to go into a notice. None of the other, what may be described as administrative steps required for the notice are set out. And in particular, which is not an administrative step such as payment, there is no reference at all to the right of appeal or the grounds of appeal. And there's no reference to the civil sanctions order, which enables the notices to be withdrawn by the Commission at any time.
And what do you say the significance is of the fact that the report doesn't contain any of those matters?
I say it has this significance, amongst other forms, that this document appears to the world to be the final word of the Electoral Commission on the topics contained within it, so that a reader of it would have no inkling, not even capable of being gained through the annex which sets out some of the law, that there could be an appeal on the basis that the notice was unreasonable for any reason, or that there could be an appeal based upon the proposition that there were errors of fact contained within it. So that, as in fact happened here, the report presented in that light leads immediately to the condemnation of those named within it, in some cases, as you may have seen, in the most virulent terms, with no restraining hand, which might otherwise be present if they were looking at the notices, of the reader being able to say to himself, herself, oh, I should notice that, Vote Leave, Mr. Grimes, or the others, they can appeal in this. This is not a done deal. And I should also notice, if it goes on to set out the grounds of appeal, that they can be on anything. This is not a situation where I'm going to have to go to the court and say I've got a nice point of law. I can go to the court and say you've got the facts wrong. And yet, none of that is present. And so the consequences, which are unpredictable, as I've said, include that which I've just described.
Can I just ask this? Would it be lawful for the Commission to publish on its website, without other text or commentary, the terms of the notices?
The notices themselves, I am prepared to accept that the notices themselves could be published on the Commission's website. And I say that for two reasons. First, because it can be said that is an incident of making the notices, the making of the notices, and second, because the notices themselves and the legislation themselves contemplate that there could be court proceedings, and if there were court proceedings, such notices could, of course, and would, of course, be publicly available. But nothing there in that acceptance gives any credence or support to the proposition that the reports could be made or published. Because nothing about the reports falls within those two reasons which I offer to the court as why, Your Lordship having asked me the question, I'm prepared to accept that those notices could be. They're not an incident of anything in Schedule 19C. And moreover, they're not subject to judicial review, which is happening here, capable of being pursued in court process.
And just following that up a little, I'm not sure it's actually fundamentally different at all, but suppose the Electoral Commission, having sent the notices, were not simply put on the website, but to produce a press release, which would be publicised in its usual way, no doubt, on social media and old-fashioned means still exist for press releases, saying the Commission has today issued the following notices, and then gave the text of the notices in relation to Vote Leave and indeed the other notices referred to in the report. But
having accepted what I've accepted from your lordship, that would be a course which could be followed. And because all that's there is then happening is the Electoral Commission is, as an incident of its function under Schedule 19C, indicating what it has done. But the report, of course, is fundamentally different.
Sorry, I don't want to take you out of your course. The report is fundamentally different in the respects you've already identified, which I have obviously carefully noted down. That is 4 named persons, no grounds identified as such, none of the administrative steps for a notice, and most importantly, what you've said so far, no reference to a right of appeal on the full range of grounds, which will indicate to people that this is not necessarily the last word.
Yes.
Are those the differences on which you rely, or are there others?
But there are other differences as well.
Well, you'll probably come to
and
that.
we'll come to those other
Okay,
differences.
well, I don't want to take you out of your course.
Because part of the rationale as to why you would not do this, why you would not have a report, is because you stand from the outset the risk that the report will be different from the notices, and that was a risk that was taken and made good more or less straight away, because more or less straight away the report was changed but the notices weren't, and were left with the same vice that had been reported to them, which led to the report being changed.
Well, we'll come back to.
Yes.
Well, I just wanted to make sure I'd understood you correctly. You'll be coming back to other differences.
I'll be coming back to other differences. Okay. I mean, I don't want the court to be under any misapprehension. We say now, in the light of the judgments that have been made, both in this court and by His Honour Judge Dite in the County Court, that the bulk of the report is conspicuously damaged or wrong, however one wishes to put it. It plainly cannot be sustained. But what I just wanted to show the court now,
Sorry, Mr. Strick,
I'm so sorry, my lady.
No. My apologies for interrupting. Can I just get this clear? You say the bulk of the report is damaged or wrong.
Yes,
You are saying that on a factual basis,
yes. I mean,
following from the County Court
the
judgment.
County Court judgment, and also the judgment which my lady, with my Lord Justice Singh and the Lord Chief Justice gave in the Good Law case, wherein you gave a clear decision that a referendum expense was different from, and differently to be categorised from, a donation. And the matters with which we're here concerned are donations.
Thank you.
But Mr. Straker, I'm not following. It's my fault. I'm not following that argument. I don't see how the vires question, which is the question in this appeal, or
Yes.
in this claim, rather, can be affected by the particular facts of what's happened in this case. Because I thought your fundamental submission is that there was no vires
That
to
is,
any of this at the outset, even if it all turned out to be accurate.
my Lord, your Lordship is entirely consistent with the approach which I follow, because I've got noted down here a little bit further on that my case retains all its strength, whether or not the deficiencies to which I refer are made good or not. I absolutely accept your Lordship's observation. The benefit which we have from the deficiencies which were apparent at the outset and which have become more and more apparent as time has gone on, serves to reveal why it is that one should have a regime which says you can do your notices by all means, stick within Schedule 19C, because we know that they can then be varied if needs be, or withdrawn if needs be by the Commission or by the Court. But you don't do a report as well, because when you embark upon a report, not merely have you got the lack of empowerment problem, you've also got the problem of these discrepancies, these difficulties which emerge. So the fact there are these difficulties doesn't, so to speak, provide the basis for the proposition there is no power. That's apparent on the legislation, but it exemplifies why it is a corporate body such as this should be held to the powers with which it's been granted and not otherwise. And it also exemplifies why it is that you have a circumstance where I can say to the court, as I've said at the outset, there is here a complete code and you don't go outside it. Why, you might say, don't you go outside that code? Well, because of the legislation, but also because you get these difficulties which have exposed themselves here. So that the court has the benefit of that, and it also enables me to say, and this argument is not actually run against me, but if it were, to say, well, what's the difference between the report and the notices and so forth, to say, no, you can't go there because of all the deficiencies which have now arisen. So I hope that provides an answer to my Lord's question, but on the fundamental part of it, your Lordship, if I may say so, is absolutely right that the power point is not affected by the deficiencies which have been exposed. Now, what I was going to do is, at this stage, just to take the court to the core bundle, please, just to see what actually happened when the report was put into existence. If you go to page 84 of the core bundle, the court will see that you're within the grounds, statement of facts and ground. And at paragraph 20, we notice what's been referred to. Paragraph 25, commission state they may also produce a more detailed commission. But perhaps I should just go back a little moment or two, because paragraph 25, which we saw, enables the production of guidance as to enforcement. They've produced some enforcement policy which they admit is not part of the statutory guidance. The commission state they may also produce a more detailed investigation report and or issue a media statement where this will further their enforcement objects, and it's the public.
Sorry, you're reading from somewhere?
Yes, I'm reading paragraph 21 of those grounds.
Yeah, thank you.
The paragraph continues by saying the Commission will notify the subject of the investigation prior to issuing the investigation report or media statement, and that is actually reflected in the guidance that they will do something first. Paragraph 22, the Commission sent by email a copy of the 38-page report to vote leave at 6:45 in the morning on the 17th of July. The Commission published the report at 7 a.m. So the prior notification, if it may be described as that, is sending it at 6:45 but publishing it at 7. And then at 7 o'clock in the morning, the BBC covered the report, and of course the only inference from that is that it had been made available to the BBC earlier than 7 a.m, for otherwise they wouldn't have been able to do so. And furthermore, paragraph 24, the Chief Executive Officer appeared on the radio that very morning, speaking to the report, and she made certain comments about evidence which were inconsistent with what had been told. And so then it goes on to record that that breaches their own policy and is a very unfortunate circumstance.
Mr. Straker, again, forgive me if I'm not following the argument. I can well understand that from your client's point of view, they may feel a sense of grievance that these things happened or didn't happen. But how do they support the essential public law complaint, which, as I understood it, you made at the outset of your oral submissions this morning, which is a lack of eye response?
Yes, it's the same answer, effectively, my lord, as before. It really is, because it exposes the grave deficiencies in this area of activity if a party such as the Electoral Commission, which is bound in by its particular powers, exceeds those particular powers. And it illustrates that is a real vice, and that it's no surprise, therefore, that one can step back and say, let's ignore all that and say, what are the powers here? Is there such a power? And if one unwinds and goes to the circumstances of supposing that the court is ignorant of all these difficulties which have arisen, ignorant of His Honour Judge Dite driving a coach and horses through the position of the Electoral Commission, ignorant of the way in which this court has said expenses are expensive, donations are donations. And then simply I say, there's no power for this. And the court asked me, well, what about, why can't it be implicit to all this? I would say, in answer to such a question of the court in those circumstances, well, contemplate these circumstances, please. And then my imagination might not get to precisely what's happened here, but it undoubtedly would contemplate the circumstances of the report differing from the notices, or the notices subsequently being successfully appealed, or the Commission responding to correspondence which we've sent them time and time again, pointing out deficiencies, withdrawing the notices. So I would undoubtedly do that in order to make good my case, but your Lordship would still be able to go away, if I may put it like this, and write a very short judgment and say, we have looked closely at the legislation and we can't find any power for this, therefore it could not happen, and therefore it should not have happened. And can I, to take this along, take the court slightly ahead of where I would otherwise have done so, to a case decided by Lord Justice Bingham, tab 17 in the cases bundle.
In fact, I think he was the Lord Chief Justice by then.
He was, but he was sitting by himself.
He was sitting in this instance.
Yes.
So in fact, my Lord is right. He was sitting as Lord Chief Justice, not as a Lord Justice.
Oh, I beg your pardon. Did I say Lord? I'm so sorry, Michael. My mistake entirely. 438.
Which is
Could you go, please, to page 439, where against letter E, in the report from the local government reports of 2000, the court will see what was being sought a declaration that the issue of a press release by the Liverpool City Council concerning the safety of some models of baby walker was unlawful and not in accordance with the council's powers. The ground was that the City Council had no power to issue the press release having regard to certain legislation which is then referred to. And then if you go to 440A to B, the court will see that the Lord Chief Justice records the issue of the press release. Issue is, did it act unlawfully? Ground of challenge is beyond the power of the council, not other grounds which might come into a judicial review application or otherwise. Then setting out who the applicant is and recording the respondents to the Liverpool City Council and the Secretary of State was there as well. And then 441 letter B, you'll see that in April 98 the council issued the press release being the subject of the application, and then in the course of the press release certain matters were stated which I don't read out. But at F, in the form 86A, the then claim form, the applicants contend that the purpose and intended effect of the press release was to give a public warning so as to call a recall of the identified products and to cause a suspension of supply. They also say that was the effect of it. These assertions not challenged by the council, just as are evidence of the prejudicial effect of not being challenged by the Commission. And then if we look on, the legislative framework is described 441G and following, and at 442D one sees reference to the Consumer Protection Act with certain powers then given. And we get to 444, the Lord Chief Justice having gone through those provisions, where he records, just below the letter B by the top hole punch, it is apparent that these provisions comprise a detailed and carefully crafted code designed on the one hand to promote the very important objective of protecting the public against unsafe consumer products, and on the other to give fair protection to the business interests of manufacturers and suppliers. One can align that with what is happening here, of course. And then he records against letter C how the submissions made by Mr. Fordham were succinct and compelling, and then he sets those out. And if you look down towards the foot of the page, you'll see that in seeking to rebut the argument of the late Miss Frances Patterson, Queen's Counsellor she then was for the Council, and Mr. Ashford Tom for the Secretary of State, relied in particular on three statutory provisions. The first of these provisions is section 142(2) of the Local Government Act 1972. Just notice that for a moment, please, because in some of the other cases my learned friend refers to, say, well, local authorities can do this, therefore this Commission can do it. There is no such corresponding power in the Commission, because local authorities have a power to embark upon publicity. And then section 111 is referred to, the incidental, and then over the top of the page, 445, a local weights and measures authority may make and provide advice. 445, Mr. Fordham accepts letter B, speaking generally it's open to local authorities to publish information relating to their activities. Had the Council issued suspension notices in accordance with section 14, that fact could he accept it have been announced to the public. This is all consistent with the questions asked of me and my acceptance as far as the notices are concerned. What, however, was impermissible was to make a public announcement having an intention and effect which could only be achieved by implementation of clear and particular procedures prescribed in an Act of Parliament, when the effect of the announcement was to deny the companies the rights and protections which Parliament had enacted they should enjoy. So to act was to circumvent the provisions of the legislation and to act unlawfully. Mr. Fordham didn't accept that section 69(5) of the Act, I don't need to read the balance of that sentence. And then he goes on, neither the Council nor the Secretary of State had an effective answer to the main thrust of Mr. Fordham's argument. A power in very general terms can't be relied on to defeat the intention of clear and particular statutory provisions.
Yeah, it might be said, mightn't it, that the analogy here would be in a situation where they had issued a suspension notice, just as here there has been a notice of civil penalty, and all the protective procedures have been gone through before the notice of civil penalty, that is to say, an opportunity to make representations and so forth. And at that point, depending on what happened in this case or in the reported case, the local authority or the Electoral Commission have given publicity to what they have done. Isn't that the better analogy?
Well, my lord, yes, I would say, because if you look at what Mr. Fordham accepts, 445, letter just below letter B, and that sentence which begins, had the council issued, that fact could, he accepted, have been announced to the public.
Well, couldn't one say, here, the Electoral Commission has issued civil penalties following the prescribed statutory procedures, giving your clients the protections in those procedures, and therefore, having done that, they can then announce that they have done so, including by a report.
Well, my lord, that then goes one further than what was said in that case, and further than the answer I've given to my lord earlier on, because I accept that they can say, press release, here are some notices that we have done. But what they can't do is do an entirely additional exercise by way of report, which on any basis, does far more than any one of the individual notices.
Well, you haven't yet shown us why it does far more, and you're going to.
Yes, but on any basis it does, because, for example, to go back to those points made earlier, it is in connection with 4, not 1. It is devoid of reference to the legislative ability to appeal, and so leaves...
Well, that's just the same. That's not doing far more, saying it doesn't refer to the appeal.
No, but it's a very significant omission from a document. But here, what the report was not seeking to do, absolutely clear, was not seeking to be a straightforward announcement, we have issued these notices.
Well, I mean, that's what I want to get to at some point.
Okay.
Clearly, it's differently worded. I take your points about the reference to the right of appeal and so forth. But isn't it simply covering essentially the same ground as the notices, saying what happened, but doing it in 4 cases rather than doing it in 4 cases compendiously, because there is a relationship between the cases, than doing it in one by one? The answer may well be no, it contained a whole lot of completely different material which went beyond the substance of what appeared in the notices, but I haven't yet seen that is the case.
And we'll have to come and address that, but I still, if I may, as a matter of principle, taking up, if I may, what the Lord Chief Justice was saying in the Liverpool case and the exchange between me and my Lord Justice Singh, if one views this as a matter of principle, one is still absent any power to do that which was done by way of this
Yes, well, I
report.
do see that point.
Because this was not assuming it to be an incident of making a notice that one can put a press release out that one has made of a notice, and here is the notice. Assuming that to be so, this is not that event. And as the Lord Chief Justice indicated, the position is one whereby, end of page 446, the present question falls to be answered as one of principle, and I conclude that the applicant's complaint is in principle justified.
Thank you. Sorry, no,
Yeah.
you
And what also is very interesting about that case, if I may respectfully say so, is that attention was drawn by both the government and the council in arguing against what Mr. Fordham was putting forward. Attention was drawn to provisions in the Local Government Act, section 142 and I think section 141 or 143 as well provide for publicity to be given, which even those provisions did not save this particular matter, and such provisions here are entirely absent.
Could I just ask one other question in relation to spins off this? You've emphasised that the council there accepted that the purpose and intended effect of the press release was to give a public warning so as to cause a recall of the identified products and cause a suspension of supply, and that was indeed the effect. Suppose in this case the Electoral Commission had only issued a press release referring to the terms and attaching the terms of the notice. Wouldn't that have had essentially the same adverse effects on your clients as the investigation report, according to the evidence, did?
No, it wouldn't, as a matter of fact, for these reasons. First, a press release which, so to speak, exhibited the notices would also carry the clear statement of an ability to appeal, in fact, in law and on the basis of unreasonableness. Secondly, the consequence would have been that there would have been notices in existence and made available, which notices were capable of being modified, varied or withdrawn, either by the court or by the commission itself. And there we remember Article 7 of the order. So that instead of there being permanently in place a document as handed out to the BBC at 7 o'clock or before 7 o'clock in the morning of the relevant day, and to other newspapers and so forth, there would have been notices available to those parties which are subject to those points which I've just made. And here we have a difficulty because we have a circumstance which is highlighted this may have been seen by the court as to what happened after the decision of His Honour Judge Dyke. Because if you look at the supplementary bundle and go to the third witness statement of Mr. Moynihan, which is behind flag 26. Now I grant you that once again I'm in territory which is in one sense unnecessary, but it directly answers your Lordship's question. This is Mr. Moynihan speaking of events after the appeal to His Honour Judge Dyke. Paragraph 5, 378. Been further proved right in my concerns about potential negative effects. The Electoral Commission, rather than doing what it should have done long ago, take down the report from its website, instead added a note to the online version of the report. The entire report was then reported widely as fresh news, as if Vote Leave and Mr Grimes had now, in 2019, been found guilty of new offences. So the report gave a false impression when it was first published, and now gives an even further false impression by remaining on the Commission's website. I offer evidence of my statement that this report continues to offer false impressions, which then wrongly colour the minds of the public against Vote Leave, by referring to the publication by someone called Carol Cadwallader last week via Twitter and so forth. I provide some of the commentary in my exhibit. And then he goes on.
Well,
Yes.
I'm sure important to your client, but we have read all this,
Yes.
and I've certainly read it.
Oh, I'm much
But
obliged.
what's the particular point you're making?
Well, your Lordship asked me the question, which touches upon, here's a report, here are the notices, what's the, so to speak, the difference between the two? And we're going to come to certain differences in due course, and that question carries on in talking about, well, surely you would be prejudiced by the notices as much as you are prejudiced by the report, or vice versa. And I draw attention to this to say that when you've put into a game a further and different ball from the one you're meant to be playing with, you're bound to get, as happens here, the kind of thing which you've read and which the correspondent, who I think is the Guardian correspondent, makes when she records, for example, they're reaffirming their findings, but it's not all that clear. And so you're getting a circumstance whereby you've put into play, as I say, the additional ball, and the tennis racket or the footballer or the cricketer can accommodate one, but he can't accommodate two.
Yes, thank you. I see how you put it.
So if I can just track us back to the 17th of July 2018 for a moment. By that time there were in existence 4 notices, all potentially subject to appeal, potentially subject to variation, and all subject to the potential for withdrawal, and a report which just sits there and which is not subject to those matters and which had been provided to all the news services. And I say, as has become apparent in the discussion between bench and bar, that when you have a clear statutory regime such as it exists here, but you overlay on it a non-statutory approach, you create inevitably a recipe for confusion. And I say that that's not a hackneyed trope, and this is where I was first making the point which I exchanged with my Lord Justice Singh, that my case retains all its strength because of the lack of empowerment, even if the very last syllable in the report were correct. But it's apparent, and was apparent from the 17th of July 2018, that the report was materially wrong, and that from the 17th of July 2018 it was used to denigrate, to diminish Vote Leave and Mr Grimes for Leave and Veterans for Britain, so as to operate, as we've exchanged remarks upon, as a kind of perpetual reprimand or sanction upon those bodies. Now, I have got a variety of illustrations to show both matters which are incorrect and matters where it was patent from the start that there were differences between the two sets of documents. And because of the character of the dialogue that we've had, I'm going to start with that last one, if I may.
That would be helpful, thank you.
And in this regard, what one needs is a copy of the report in the core bundle, tab 10, and one needs to alight upon page 100 I beg your pardon. Witnesses. 320. Yep. I beg your pardon. Page 104. So at page 104, the court will see that at paragraph 317, some important matters are recorded. After the media reporting of allegations, we were approached by the lawyer for 3 vote leave officials. We were told the operations director was willing to speak to us. We responded that in the first instance we would wish any evidence to be sent to us. And then if one looks on, one sees that 320, during the 28-day period, we were contacted again by the legal representatives for vote leaves, operations director, head of outreach and national organisation. We were told that these individuals now had evidence to give us. We asked for the evidence to be provided as soon as possible so we could look at it. None was sent, but the legal representatives did send a letter and some documents commenting on the notices we had issued to vote leave. So a serious point is being made, touching upon want of helpfulness, if I may so describe it. With that in mind, could you please take the supplementary bundle and go towards the end of the supplementary bundle, where you will find behind tab 32 an exhibit to Mr. Moynihan, which includes correspondence from a well-known firm of solicitors, Peters and Peters.
Which particular page?
If you go to page 721, you will see that Peters and Peters were acting for 3 named officials who were all part of or working within vote leave, and are the 3 who are canvassed in the report.
Just so that I can adjust my notes if necessary, are these documents to which we're taking the skeleton argument?
Are they referred to in the skeleton argument? They're not directly referred to in the skeleton argument, no.
Fine.
And then if you having noticed for whom they act, noticed that they had written a long letter complaining about certain matters, and then 759, they write further to the publication this morning, so this is the 17th of July, of the report, page 760, we demand that you correct.
Sorry.
I'm so sorry, my lord. 760, paragraph 4, in the middle of the page. We demand that you correct no later than 3:30 today 2 factually inaccurate statements made in the report, and request you clarify your approach to the evidence, information and explanations that were submitted to the Commission by our clients in advance of the report being published. And then it records what the report set out, and we've looked at that paragraph. It is completely untrue, paragraph 6, that the Commission asked for the evidence to be provided as soon as possible so we could look at it. We have attached to this letter the full email thread between 2 named people. At no point does Miss Edwards ask for any evidence to be provided to the Commission. In fact, in her final email, she explains precisely why no such evidence was sought. Therefore, unless you're able to point to some correspondence which we must have met, of which we are unaware, you must concede this assertion is false and be corrected immediately. Paragraph 320 also states, in respect of the Commission's purported request for evidence, none was sent. This is also completely untrue. Within the 28-day period, we caused to be sent the following evidence to the Commission, copies of emails between, a statement from. Unless you're able to explain why it's not evidence, you must concede that this assertion is false. Now, what this all led to was correspondence in which eventually the Commission said that they would change a little bit as far as the report is concerned. And if you go back in the supplementary bundle to arrive at Mr. Lardner's witness statement, which is
28.
yeah, and if you go to page 486, you'll arrive at a version of the report 486. Now, could I ask the court just to make a little notation here, because Mr. Lardner says, see page 400 at the bottom of the page, that this exhibit is as it was originally published on the 17th of July 2018. As we will see in a moment, that cannot be right, because if you look at this...
So where does he say that?
Foot of the page 400, one is redirected to the report as it was originally published on the 17th of July, which I exhibit here at AL10.
Yes, thank you.
And that cannot be right, because if you look at page 500, you will see that at 317 the sentence has been revised.
Yes.
See the footnote. That's in the light of the correspondence I've shown you.
Yes.
And
Well, let's just, Mr. Crumple, that seems pretty convincing to me.
I think that's probably
So
right.
Mr.
I'll
Lardner
double check how
Mr.
it came
Lardner
out.
made a mistake. Well, perhaps you can check.
So,
Yeah, thank you. Yeah, well,
And
let's
then if
assume
you
that's
look
right
at
for the time being.
320, I haven't got 320 has had something deleted from it, I believe, if one contrasts with page 104 of the core bundle. Yeah, a bit in the middle has been removed, I think.
But to just, what would be most helpful, just tell us, going to the original 320, on page 104 of the core bundle, which words have been omitted?
It's the sentence beginning, we ask for the evidence to be provided as soon as possible so we could look at it.
That's it, my lady.
And then none was sent remains in.
Yes. That's absolutely right. And so we've got the report being subject at some stage to a change in consequence of what Peters and Peters had drawn to the attention of the Commission. But if one goes to the notice...
Mr. Coppell, again, that looks pretty convincing, and it also looks as though the later version of the report ought to have footnoted that this too was a change. Perhaps you can just take instructions on that and deal with it after lunch. But, yeah. Sorry, Mr.
Not at all, my lord.
Straight, I just wanted
What I was
nail that down.
going next to do was to take the court to one of the notices, tab 14, where...
Just give me a moment while I finish my note on this.
While my lord is finishing his note, can I just refer you to page 487? Because that seems to be the front sheet of this version of the report. And there you see a date on it, 17 July 2018.
Sorry, my lady, which?
Page 487.
487, yes.
It seems to be the front page of the report, and the date on it is the original date.
Yeah, identical to page 91 and the...
Yes.
Yes.
But I think my lady's point, I doubt if this is at the heart of the case, but that if there is a public document like this and it is amended, not only should the amendments be meticulously recorded in the text, which it doesn't look as though they were, but there should be something on the front sheet to say version 1 revised. Exactly what degree of explanation you'd have to give would depend, but it ought to be absolutely clear that this is a new version.
Let me check, because I understand that these were taken from web pages, which may have been archived, so quite how it pans out. But I'll check what the position is, and if there were shortcomings in the way in which the changes were notified, then we'll let the court know, of course.
Yes. Yes, so that's your first difference between...
What I haven't done yet, my lord, is to show your lordship the notice so that one sees...
yes, this is slightly a hybrid. So far you haven't so much been showing us differences between the report and the notice as what you say are errors in the report itself.
Yes,
Okay.
but I suppose it depends what version of the report one takes. But if one takes that version with the words omitted from it and looks back at the notice of decision at page 138, you will see that under section 5, about a third of the way down the page, the Commission's alleged refusal to interview, and then it refers to representations from those three people for whom Peters and Peters were acting, and at 119 claiming not the case that the Commission failed to provide an opportunity for any representative. The Commission has been clear throughout the investigation that if vote leave 120 had held evidence that suggests they've not committed the offences, then it should be provided. The Commission has not received evidence from Mr Parkinson, Miss Watson or Miss Woodcock. So what we have is, except a hybrid, but we have a circumstance whereby immediately on publication Peters and Peters say you've got this wrong, most distinctly, obviously untrue. The change is made to reflect what Peters and Peters say in the report, but there's no corresponding change in the notice.
But then, can I be clear about this? The notice as... Sorry, the report as published reflected the terms of the notice. Is that right?
The report
in
as...
this respect.
Yeah, the report as
But you say-
originally published was in correspondence with page 138.
Yes, let's make a note of that. Okay.
I believe that to be the case.
But then, isn't this then a point against you? Because I thought what you were saying was that the vice, or part of the vice of the report, was that it said things that the notice didn't say. The point you made is that it did say what the notice said, but they were both wrong. They corrected the report, but they didn't correct the notice. Have I got that right so far?
Well, yes. I mean, I was responding to your lordship's question as to please show me a difference between the notice and the report. And I had in mind, as one of the things that I was going to show the court, this Peters and Peters exercise whereby they secured an alteration in the report, though not, of course, the report which was disseminated to the world on the 17th.
Well, that's a different point, but I've
But
obviously got that.
they secured an alteration to the report, but that put the report as different from the notice.
Yeah, but surely that then gives you a ground of appeal against the notice. The notice was shown to be wrong, as was conceded in the report, I think what you're saying.
Yes.
And insofar as that was an element in one of the offences for which a civil penalty was imposed, that would give you a ground of appeal, wouldn't it?
Well, it no doubt would touch upon a ground of appeal, or give independently a ground of appeal, no doubt. I don't dissent from that proposition at all. I mean, we had lots of grounds of appeal.
Yes.
And unfortunately, as your lordship will have seen, and the evidence is not in any shape or form challenged in this regard, Vote Leave Limited gave up on the appeal because the game for them, as far as
Well,
the game, was
I
not
understand
worth the
all
candle.
that. I'm just looking analytically
Yes.
at what the point you very clearly made to us shows and how it advances the particular argument before us. And I think probably to go into all the circumstances of why you didn't appeal or didn't persist in the appeal, that doesn't really advance the argument.
That's absolutely right. It's just something not to be held, so to speak, against.
No, I'm not holding it against Vote Leave at all. I'm just trying to analyse, as it were, what it goes to.
Yes.
Yeah, thank you.
What we have seen through this example, and as I say, I picked out a number of matters to show the court in connection with an offence, in connection with common plan, as to why it is the report can't now stand, and also I picked out this particular matter
Yes.
as an illustration of the difficulties which arise and the mismatch which can occur between notice and report. But that's, so to speak, a clear illustration of the capability of there being mismatches. But what I haven't got, I have to confess to the court, is, so to speak, a line-by-line comparison between the notices, plural, and the individual report, to see whether or no matters were expressed differently in the one from the other. Maybe we can do some further work upon that, but I haven't got, so to speak, a schedule of that to present.
Well,
to
don't
the
worry.
court.
It clearly isn't. It's come up in the course of argument.
Yes.
If it was an important part of your case, you would already have produced such a schedule, so I'm not asking you to produce one now. No, that's been helpful, thank you.
I'm much obliged, my lord. Much obliged.
Mr. Straker, I'm sorry to interrupt your submissions, but can I just ask, so I'm clear in my mind, what the fundamental submission is that you're advancing? I think it is that even after those corrections had been made in response to the letters from Peters and Peters, so let's assume, for the sake of this question at least, that from that point onwards at least, the report was entirely accurate. But I think your submission in law is that there was still no power in the Electoral Commission to make and publish such a report.
Your Lordship is absolutely right, because one is in a vacuum in terms of identifying the power for it. One simply can't do that. And your Lordship will recollect that in my skeleton argument, I went through the various statutory provisions which could be alighted upon. And I referred to the fact that the best candidate was section 145, but when one looked at section 145, it plainly wasn't anything to do with section 145. And one also notices, of course, that section 145 is concerned with particular provisions of the Act and not with section 147 with which we're concerned. So that one is in a vacuum in saying, where is this power? In an ordinary case for a local authority, one can readily identify the power, and life is made much easier now for local authorities, as your Lordship will know, in consequence of the Localism Act, which says local authorities have the powers of a natural person, save for certain matters which are restricted.
We don't have that.
We don't have that, nothing
What
like
we
that.
do have is paragraph 2 of Schedule 1,
That's right.
which is, so far as material, the same as section 111
That is
of
correct.
the Local Government Act 1972.
That is correct.
I think the simple argument that's made against you is that's enough. That it was calculated to facilitate, or was incidental to, one of the other functions which the Act confers upon the Electoral Commission.
Yeah, well, then one gets to the question, well, what function?
What the judge, Mr. Justice Swift, held in refusing permission at the renewed hearing was that he found that in section 145.
Yes. Well,
And that's either right or it's wrong.
Yes.
We'll have to consider that.
your Lordship's absolutely right, but your Lordship is also right as to the fundamental character of the submission made. Can I, your Lordship, having raised the question of section 145, look at that now? And I appreciate this means that I'm going to be slightly out of sequence, but can I do so? Because it's plainly an important aspect.
Just before we get there, let's just take stock of where we are. That's an important exercise which you ought to do, and I
Yes.
agree with you, it's sensible to do now. Once you have done that, how much more of your submissions are left? We obviously will have had, by the time we've done that, probably the whole morning or something like the whole morning, and we've got to leave time not only for Mr. Cropple but for you to reply,
Yes.
Mr. Cropple. So I just wanted to get a route map in my mind.
Well, I've been conscious of time because
Yes, no,
I'd
you've been very economical so
Well,
far.
I've
if I may
tried
say
to
so.
be,
Yes.
and I've tried to have in my mind to say to myself, please try and sit down shortly before lunch, but I don't think I'm going to be able to achieve that at the moment because I do have some other matters to develop.
Well, don't worry, let's not. We'll go to the 145 point now because I respectfully agree, my Lord, that that's important. That's the basis on which it was decided against you below. Once you've dealt with that, you may have to decide to cut your trade according to your cloth.
Understood, my lord. Can I then go to 145, which is in the legislative bundle, page 23. And it may be useful to have open at the same time my skeleton argument, which tab 14 core bundle,
Yes, which particular
paragraphs 42 and following.
Yes, thank you.
And so, as my Lord Justice Singh points out, this is the section to which Mr. Justice Swift referred and said this is the section to which the report is an incident. And if one looks at subsection 1, must monitor compliance with, and if one asks oneself the question as to whether a report about Schedule 19C made under Section 147 is part of what is to be monitored, the answer comes back no, because the Commission must monitor compliance with certain restrictions and requirements, including those which are mentioned, but not including 147B or 147, I beg your pardon, 147 and not including either Schedule 19C or 19B. And then if one also asks oneself the question, is this in fact an exercise in monitoring compliance with something? The answer is no, it is not. Because monitoring records material and information being gathered for the purpose of monitoring the referendum, which this was not, because the referendum and the referendum period finished by definition on the 23rd of June 2016, because your Lordship will realise, my Lady will realise, the position is one whereby under the legislation the referendum is extant, and it's extant for the referendum period, which ended on the 23rd of June 16. So that monitoring does not fall within this exercise.
Would that be right? Suppose there had been non-compliance with requirements about expenditure in relation to the referendum, and those were investigated after the end of the referendum period. Wouldn't that be a function in relation to the referendum?
Well, what
Or
one's
monitoring, wouldn't that be a monitoring function in relation to the referendum?
Well, what one's looking for is something incidental to monitoring.
Yes, but your point wasn't on incidental at the moment, it was on monitoring. I was just questioning whether what was being done here, not the report, but what the actual things reported on weren't monitoring.
Well, I would say as a matter of English, as a matter of fact, that this is not a monitoring exercise which was undertaken, but rather an investigative exercise that was undertaken retrospectively in connection with past events which were capable of being monitored at the time.
So your point about monitoring is it effectively means contemporaneous.
Yes.
Okay.
And it's as if, I mean, it's the monitor at school monitoring what's going on in the form room or whatever it is, and the headmaster subsequently taking action against the pupils, but they're two different issues. And this was not within the concept, I would respectfully suggest, of monitoring.
You would say that was supported by the fact that subsequent investigation is the subject matter of section 146 incorporating 19B, and sanctions for any non-compliance so revealed is the subject matter of 147 incorporating Schedule 19C.
That's correct. And if you look at section 141(1)(a)(3), the monitoring is in respect of restrictions and requirements imposed by sections 143 and 148. And so 146 and 147 are conspicuously absent.
Yeah, well, you
from
made that point, yes,
Yeah.
that's the one I was just making
Yeah.
back to you, yeah.
And so that's monitoring, and take all reasonable steps to secure compliance with, I say once again, is a contemporaneous exercise as far as the referendum is concerned, because if one is looking at the parts with which this is concerned, you will see set out at paragraph 46, page 153 of the core bundle of our skeleton, that part 7 is there discussed and described, precise timetable, provisions are all referable to referendums as so understood, expenses can't be incurred after the referendum period, and so if one goes back to secure compliance with, the purpose of 145 is to enable the Commission to do things so that during the referendum period, referendum expenses beyond the financial limits are not incurred, and then it deals with all the circumstances which had to have happened, so as to enable me to say at 48 that there was no function within part 7 to which a non-statutory report dated July 2018 could be an incident. There was no function in part 7 to whose performance the report was conducive. And so if one takes it in either way, whether by saying, is this part of taking a reasonable step to secure compliance with part 3 to 7, one still looking there at the contemporary steps taken to secure compliance with what happens during the referendum, and it's not incidental to any of them, and all that is supported again by the fact that section 146 and 147 are conspicuously absent from section 145(1)(a)(3).
The way which Mr. Justice Swift, I think, interpreted this was not the way that you're contending for. You may be right, but he, I think, construed it in a broader way and took the view that this isn't limited to a particular referendum in the past. What it's actually saying is take all reasonable steps to secure compliance with, and then the specific provisions set out. In other words, potentially including future compliance by other people in respect of possibly other referendums.
Yes, I mean the problem with that is a number of reasons, I would say. I mean, first of all, I would respectfully suggest that the language of monitoring and securing compliance with restrictions which relate to the conduct of the referendum is looking at something contemporaneously at that stage. Problem number one. Problem number two is that the Political Parties Elections and Referendums Act provides for a basis upon which referendums can come to be conducted. But there has always to be a further Act of Parliament, as there was here, the European Union Referendum Act, which provided for the referendum, provided for the question, and provided supplementary provisions altering in very material respects in a number of ways some of these provisions in the 2000 Act, so that you have a circumstance whereby you know for sure that the next referendum, whatever it be on, is going to require some further and different legislation. And so that may say we're going to everything from what happened in 2016 and plant it into legislation which I will suppose is going to happen in 2020 or 2021. Or it may mean that you are going to say in 2020 or 2021, no, we don't want that, because we are unhappy about what in fact then happened, and we want something different, whether it's by way of altering the franchise, by way of altering the requirements as to amounts capable of being spent, by altering the way in which the provisions operate as to parties working together or not working together, all those matters. So, second problem, as far as Mr. Justice Swift is concerned, is that. And the third problem, as far as this is concerned, for Mr. Justice Swift, is this, that the referendum is conducted according to a very particular timetable. And it's conducted according to a timetable which includes provision as to there will be, and this happens under the conduct regulations of the referendum, after a year, a destruction of all the papers connected with the counting in the referendum. And there are a multiplicity of papers, so you cease any ability to discover what went on in the lead up to the ballot papers and so forth, and the postal votes, etc. You also have, within a period of 6 months, to make your return, which return is to be destroyed after 2 years or recovered with copies no longer available. That's section 124 of the Act. So that when you get to a circumstance of Mr. Justice Swift saying, well, this is all prospective for a referendum, you have a circumstance where you're talking about a referendum which may be, if it comes to pass, assuming that Parliament says we want another referendum, on entirely different terms or variants of this, and so it's going to be unhelpful rather than helpful, and in any event, by that time, a lot of the material which might otherwise have informed these matters so that people could look at them has gone, has to go, so that at the moment, well, within 2 years of the return being made, anybody in the public can go onto the Electoral Commission's website and look at a return which has been made. After 2 years, if you've made a return, you're entitled to say, I want it back, please, and they have to take it down from the website, section 124 of the Act. And so if you're looking at something like this report, and you want to inform yourself as far as what's going to happen next, well, I better have a look at how the return played out as far as Mr. Grimes is concerned, or believe, or vote leave. You're not going to get anywhere. And so the whole concept of this must be, in my respectful submission, to go back to what is actually going on here as far as section 145. What is it seeking to do? It's seeking to enable the referendum, at the time the referendum happens, to be effectually conducted. And I use that expression very deliberately because the court may know that a returning officer at an election has, under section 23, I think it is, of the Representation of the People Act 1983, the power to do all things necessary effectually to conduct the election. And that power is plainly, and has always been seen, as a power referable to the time of the election, We've had democratic elections and so forth in this country for a long time now, and you won't find anywhere a report by a returning officer post an election saying effectually to conduct the election that is to come, what about X, Y and Z? It's simply not there. Yes, yeah, and it's being pointed out to me that we've got, as I've mentioned, there's a so-called regulated period, 1st of February 2016 to the 22nd of June 2016, a pre-poll report, February 16 to 21st of April, a second pre-poll report, 22nd of April 16 to 16th of 12th of May, and the third pre-poll, 13th of May 2016 to 9th of June, and the fourth and final pre-poll report, the period 10 June 16 to 22nd June 16. That's from the Electoral Commission's record of what has to happen. So those are the points on 145, I would respectfully say, and they of course all sit alongside a matter which wasn't discussed by Mr. Justice Swift at all, and no doubt mea culpa as far as that is concerned, the clarity of the approach shown by the Lord Chief Justice in the Liverpool City Council case.
Yeah. What do we have to cover still?
Right. Can I then, seeking to do this matter as I say, as efficiently as I may, and just if I can shoehorn certain things.
Yes, of course.
Because, as I say, I have no desire to run contrary to my desire to be able to sit down.
Well, let's be clear about it. I'm not imposing an absolute cut-off.
No.
It was you yourself who said that was your plan. These things sometimes go difficult to predict. But if you go far into the afternoon, Mr. Coppell will get restive. Yeah. So I just think you need to think about what are the key points you want to make. If you would like this to rise now and sit at 5-2, so that you can just have a chance to see what prioritisation you want to do, that might make more sense.
I'd be very grateful for that, my lord. And can I signify to your lordship what I have in my mind to do, which will be to say, and possibly to say this I don't want to commit myself in something like a quarter of an hour or so. I would have been drawing attention in this way to these matters, and then to say I would further have been drawing attention in this way to these matters, which will be an abbreviation rather than an elaboration of the submissions otherwise that I
whatever you think is the most effective way of dealing with it, but certainly saying these are the points I want to make, and they're developed in the such and such paragraphs that might serve as an argument, is a very sensible way of dealing with it.
Yes, I mean slightly more than that.
No, I'm sure, but well, I think we'll rise now. We will, it's a slight indulgence, sit at 5-2, and we don't expect you to be very much longer.
Much obliged, my lord. Are you going to kick us all out?
Yes, right.